Hi, my name is Alexa Moran, and my case studies are on New York Times versus Sullivan and Geertz versus Welch. In this land case, the respondent was elected official in Montgomery, Alabama, by the name of L.B. Sullivan, and the petitioner was New York Times. The New York Times had carried a full page of advertisement called Heed the Rising Voices, and they were petitioning funds to help prevent Martin Luther King against Alabama, the perjury indictment. This ad depicted several facts that were not properly vetted by the news publication or the police force of Montgomery, Alabama, regarding the human rights of the protesters. Mr. Sullivan considered the publication an attempt to ruin his image even when his name was not explicitly revealed on this publication. He was the one that supervised the police department, and he was firm that the characterizations of the police forcing acting to control the crowd of Negro students participating in the protest, including the use of tear gas, intimidation, and terror techniques, involved him. These allegations and some other statements were questioning his capacity as commissioner. In this case, the Supreme Court adopted the actual malice and gave it constitutional significance. They had to prove that there had been failure to provide safeguards for freedom of speech and of the press, as said in the First and 14th Amendment. A public official suing for defamation must prove that the statement in the question was made with actual malice. Malice is basically lack of investigation and not really having all the information. The actual malice standard requires that the plaintiff in a defamation or libel case is if public figure prove that the publisher of the statement in question knew the statement was false or acted in reckless regard of its truth or falsity. The Supreme Court's decision on this case and adoption of the actual malice standard allows for reduction in the financial hazard for potential defamation claims. This way, public officials are no longer able to use these claims for political criticism. The court ruled the Times 9-0, which means that Sullivan lost the case. In their decision, they said the First Amendment protects the publication of all statements, even false ones, about the conduct of public officials except when statements are made with actual malice. The second case that I decided to do was the one Geertz versus Welch. Geertz was a lawyer hired to represent a victim's family in a civil litigation against the office that killed their son. He petitioned his case. Mr. Geertz, on the other hand, was a private attorney, not a public figure. After Mr. Welch was hired by the family of Ronald Nelson, the young man police officer, Richard Nusio was shot to death. To represent them in the civil suit against the officer, a publication by John Birch Society ran several articles implying that Mr. Geertz was a member of the National Police being developed and that supported communism. They reported that Mr. Geertz had a criminal record, which the publication never bothered to confirm. Geertz said that the article defamed his reputation as a lawyer. American Opinion argued that Geertz was a public figure, applying the New York Times versus Sullivan standard to anyone who was sufficiently public, not just government officials. The publication made no attempt to confirm his information they publicized about Mr. Geertz. Later, an editor of the magazine signed an oath where he conceded that he had not investigated the claims they portrayed as truth. The court ruled on the side of Mr. Geertz, who only needed to prove negligence, and they rewarded him $50,000. Due to the time in which this case occurred, I believe that Mr. Geertz's reputation could have been ruined as a reliable, serious attorney. Communism and its followers were not the most favored subject during the Cold War. People would harshly judge anyone that had any ties to communism, and therefore they would not trust anyone involved in it. He would have probably lost his way of livelihood, his career, and possibly his relationships, which might have included his family. In order to avoid the lawsuit, Welch should have independently confirmed the information they had obtained about Mr. Geertz. Relying on a whole sole individual or even on word of mouth to accuse Mr. Geertz of any association with communism was irresponsible. If it was true that it was difficult to prove, there were other ways to do it, especially during this time. Worse than that, saying that he had a criminal record without any proof is not only irresponsible but also dangerous to Mr. Geertz's private life. There are different Florida defamation laws: elements, defamation per se, public and private figures, criminal libel, actual malice, and negligence. Learning the outcome also means that although there's freedom of speech in the United States, one must be very careful on how to use that right. The fact that the First Amendment applies that everyone provides us with safeguards on how to use it as well. Verifying information through several independent sources is very important in order to avoid lawsuits. It is very important to know what the information law is on the state that you are conducting business. Knowledge is definitely power and vice versa.